So hi everyone, my name is Ella Shoup and I'm part of the policy team here at Holistic AI. I'm joined by my colleague Nikitha Anand, a policy analyst at Holistic. And just to give you a little bit of background on our company, we are an AI governance platform and we empower enterprises to adopt and scale AI with confidence. Our team is multidisciplinary. We have colleagues from machine learning, AI, data science, legal, and of course, policy backgrounds. And we've assured over 100 enterprise AI projects covering more than 20,000 different algorithms. And our clients and partners include Fortune 500 organizations, SMEs, governments, and regulators. And over the past few months, our policy hours have covered a variety of topics in the AI policy ecosystem, from the EU AI Act to the NIST AI RMF. And this month, of course, we will be discussing the very dynamic US AI policy landscape. And so, just to give you a sense of the overall picture, there's not currently a comprehensive binding AI legislation in place in the United States. However, that does not mean there's been no response or activity on it. We've seen a lot of activity, especially from the Biden administration, federal agencies such as the Department of Commerce and the Consumer Finance Protection Bureau, and of course, Congress. They've introduced many different bills and held numerous hearings on AI, and we'll be going into these in depth later. And then, in the absence of binding federal legislation, states and local municipalities have taken a more active role and begun to pass compulsory legislation. So, first, we'll be covering federal AI legislation. Nikita, could you tell us more about what's happening at the federal level on AI policy?
Of course. So when trying to decipher federal AI activity, these can be split into the following categories that you can see to get a better understanding. So there have been efforts to introduce both horizontal and vertical legislation so far. There are some sweeping AI governance efforts, as you mentioned just now, through the Biden executive order, for example, as well as the National Institute of Standards and Technology's release of the AI risk management framework. And there have also been several other joint guidances that have been released by federal as well as other international agencies, through which there's been a continuous reiteration that even if AI specific legislation does not pass, existing laws do indeed still apply to AI.
Right, so this is a lot. Could you tell us which ones are proposed and which ones are in effect?
Of course. So the laws that you can see on the right-hand side are the ones that are already in effect. So it's important to note that those that are already in effect do not yet mandate any actual requirements or restrictions on the use of the technology, but instead they cover a range of different related things. So starting with the AI Training Act, it mandates the Office of Management and Budget, and as well as related agencies, to develop any specific AI training programs for federal workforce members. Next, we have the CHIPS and Science Act, which establishes the Creating Helpful Incentives to Produce Semiconductors Fund. And this essentially provides funds and incentives to support domestic semiconductor manufacturing, as well as other research and development programs under which AI will be a big focus. Then you can see the Identifying Outputs of Generative Adversarial Networks Act, which essentially instructs NIST as well as the National Science Foundation to fund research on these networks and develop relevant standards. And lastly, we have the four National Defense Authorization Acts. So the 2020 Act, for example, gave NIST the mandate essentially to create the AI risk management framework. And under the most recent act in 2024, this funds further research into AI, specifically detection and watermarking, for example. And it also requires the state and defense departments to establish chief AI officer roles internally. So besides these, it is important to note that yes, there are essentially no other laws that are actually in effect at the federal level. So the material that we will be delving further into now will go deeper into horizontal legislation instead. So given the almost 100 laws that are in progress at the federal level alone, it is easy for us to, of course, pick out the most relevant ones as well as highlight any overarching excuse me, any overarching themes that we can see. So there has been legislation specifically targeting private sector companies, which is the first approach that we can see over here. Under this, we have several acts which essentially serve to create specific standards, metrics, impact assessments, as well as transparency requirements. Excuse me again, for for automated decision-making systems. So the ones that people are most likely to be most familiar with, for example, is the Algorithmic Accountability Act, which has been introduced not once, but thrice at this point. And this targets systems that make critical decisions that could impact people's lives in terms of essential services. The next act that we have, the next approach that we can see, is the acts that target federal use of AI systems. For example, the Federal AI Risk Management Act that would make the NIST AI RMF legally binding for federal agencies, under which NIST must also issue guidance incorporating the AI RMF if this does pass. And we also have the Transparent Automated Governance Act, in which agencies should essentially be transparent in terms of when they're using AI systems that especially make critical decisions about people. And the last category that we can see over here is acts that don't actually target any specific AI systems, but instead seek to improve the overall AI ecosystem, especially in furthering research and innovation. So we have an act that would require NIST, for example, to establish test beds to support the development of trustworthy AI systems. We also have an act that would create a national AI commission in which it should essentially establish recommendations for a comprehensive framework after which the commission can terminate. And lastly, we also have an act that would require a potential study on the environmental impacts of AI and would also need NIST to develop a voluntary reporting framework. So it is quite clear that at the horizontal level, laws are quite less mature and comprehensive compared to the EU AI Act, for example. And given the reintroduction multiple times of certain bills, such as the Algorithmic Accountability Act, it is clear that there is some reluctance around passing a sweeping piece of legislation. So we're more likely to see a patchwork of different actions that target AI instead.
Great, thank you. And before you mentioned vertical legislation, and I was wondering if you could tell us a little bit more about that.
Of course. So moving on to vertical legislation, we can see that there have been laws introduced in the sectors that you can see on the screen. So those are generative AI, HR tech, insurtech, autonomous vehicles, and online platforms and communications. So going further into the laws that have been proposed specifically for generative AI, these can also be split by approach as well. And so the first is ones that target the proliferation of deepfakes, under which acts have essentially been introduced to reduce any sort of distribution of non-consensual and explicit imagery. And these introduce penalties as well. So one of them, the Protect Victims from Digital Exploitation and Manipulation Act, further establishes extraterritorial jurisdiction in certain cases. There's also an act specifically within the finance sector called the Preventing Deepfake Scams Act, which would essentially create a task force to understand the deepfake issues that are currently targeting the finance industry. The second approach that we can see is bills that are introduced to target AI-generated content. So under these, the acts that have been introduced, for example, the AI Disclosure Act would require that any content generated by AI must have a disclaimer on it, and this would include content that has been generated by LLMs such as ChatGPT as well, for example. Next, we have under this the AI Generated Content Act, which would require a watermark for material generated by AI. And both of these acts are actually come under the enforcement of the FTC under the rules that concern unfair or deceptive practices. And under this category, we also have the No AI Fraud Act, which a bit differently seeks to provide for individual property rights for voice and likeness. So this gives individuals legal grounds to sue to protect their identities from AI abuse, including deepfakes. The next category that we can see here are specifically targeting robocalls, with one main act that was that was introduced called the Do Not Disturb Act, which strengthens certain provisions on robocalls and telemarketing restrictions. So penalties would fall under the FTC again. And while this is still in progress, however, the Federal Communications Commission has actually released a declaratory ruling in February of this year, making AI-generated voices in robocalls illegal. So this is effective immediately because it essentially confirms and clarifies the authority that the SEC has. And so while the act is actually in progress, there is already a binding sort of rule targeting AI-generated voices in robocalls. And the last category under Gen AI is specifically maintaining election integrity amidst the rise of deepfakes that we can particularly see, especially over the past couple of months or so. So AI misuse in elections has been spreading, for example, with, a robocall featuring the digitally altered voice, imitating President Biden, as well as several deepfake videos of former Indonesian presidents and the current UK Prime Minister, for example. So under this category, the Protect Elections from Deceptive AI Act would essentially prohibit any distribution of deceptive AI-generated content of candidates for federal office and would also allow the candidates to sue for damages. Next, we also have the Candidate Voice Fraud Prohibition Act, which would essentially ban the distribution of those political communications that contain deceptive AI-generated audio of candidates, with certain exceptions to news, satire, or different types of broadcasters. So this is all for generative AI, and as you can already see, the landscape is quite broad, but going further into the different sectors that we can see over here. So firstly, within HR tech, the acts that are proposed under this particular vertical, you essentially seek to address both the use of automated decision-making systems as well as workplace surveillance. So, for example, the No Robot Bosses Act would seek to prohibit employers from relying solely on automated systems when making employment decisions, and would also require the continuous testing of these systems, as well as the disclosure to employees about their use as well. Next, we also have the Stop Spying Bosses Act, which would apply to both federal and non-federal employers, which would require the disclosure to workers and applicants of surveillance that is being conducted in the workplace, how this data is being collected, and what it is used for as well. But of course, several types of data are prohibited from being collected, such as health-related information. In the insurtech space, there has been one main law that was introduced called the Prevent Auto Insurance Discrimination Act, which essentially seeks to prohibit private passenger automobile insurers from using certain types of income proxies, such as employment status or occupation, to essentially determine insurance rates or eligibility. So while and under insurance still, while this is not a bill in itself, there has also been a bulletin issued by the National Association of Insurance Commissioners regarding certain principles on AI. So this reminds relevant businesses that they must comply with all insurance laws and regulations, including those on unfair trade practices and discrimination, and remain cognizant, of course, of the principles we all think about when it comes to AI, such as compliance, transparency, and safety. Autonomous vehicles is interestingly the only vertical where a bill has actually been passed, but it is not in effect yet. So this is called the Self-Drive Act, which essentially aims to ensure the safe and responsible development and deployment of highly automated vehicles, while of course addressing concerns around safety, cybersecurity, and privacy. However, this act was passed in September of 2017, so that makes it almost 7 years since it was passed, but it has not been signed into law yet. So it is quite unlikely that this will actually come into play, and we're thus likely to see a lot more state-related and state-level activity for AVs. And lastly, regarding online platforms and communications, the approaches that are taken here are actually quite different. So for platforms, for example, there has been the introduction of the Digital Platform Commission Act to essentially create a commission, as it sounds, to regulate platforms focusing on fairness and safety, and essentially to address the unchecked power of digital platforms. And civil penalties may apply of up to 15% of the platform's global revenue of the preceding year. There's also the Platform Accountability and Transparency Act, which seeks to promote research into the impact of digital communication platforms on society by establishing a joint research program between the National Science Foundation and the FTC. And platforms are essentially required to disclose data to researchers in this program, and non-compliance with this rule will be treated as a violation of the FTC Act. So for communications, however, this specifically focuses on the misuse of AI in politics, similar to certain bills that have been introduced for generative AI. So the Real Political Ads, for example, amends the Federal Election Campaign Act and makes AI-generated content in political campaigns to require a disclaimer. And we also have under this the Political Bias Emails Act, which essentially makes it unlawful for any commercial email service provider to use a filtering algorithm to label any email from a political campaign as spam unless the receiver has taken specific action to apply such a label. So once again, the FTC will also be enforcing this act. So as that can be seen very clearly, there is still a lot of fragmentation at the federal level, and most laws are still in very early stages. So it really remains to be seen whether these will come into effect. But with this lacking consensus, we're definitely more likely to see a patchwork of executive branch actions, a greater push at the state level, and as well a greater application of existing laws to AI as a reminder to companies that they cannot circumvent the regulation of AI.
Right. So, as you said, the executive branch under President Biden has been taking an active role in AI policy. Of course, a lot of this isn't binding. Could you tell us a little bit more about what his administration is doing on this front?
Of course. So, as mentioned a couple times already, there's the executive order on the safe, secure, and trustworthy development and use of AI, which was released in October of last year, which essentially mandates over 50 federal entities to take over 100 specific actions to ensure the safe and secure development of AI systems in different policy areas. And some of these actions, for example, are the completion of risk assessments for the use of AI in every sector of critical infrastructure, as well as the pilot of new AI tools, of course, to identify vulnerabilities in government software systems by the Department of Defense. So April 2024 actually marks the 6-month mark since the executive order was released. And in that time frame, all of the agencies that had, so under the executive order as well, NIST has been given additional responsibilities to create a companion resource to the AI RMF specifically for generative AI and release a profile, which it has done. So all of this really shows that there's really an increased likelihood that especially in federal government, executive branch actions would be more successful in furthering AI policy and legislation, and especially with the increased adoption that we can see of voluntary and use case agnostic standards like the NIST ARMF.
Right. We always know with the NIST AIRMF that it's voluntary. They always tell us that. So if there isn't any binding AI legislation in Congress or from the Biden administration, what existing regulation might apply to AI?
Sure. So, agencies really have reiterated their commitment to applying existing laws to AI. So, in the first of the relevant policies that they have released regarding this, there has been the policy from the Office of Management and Budget on advancing governance, innovation, and risk management for agency use of AI, which essentially directs federal agencies to further their innovation and governance efforts while at the same time managing the risks that arise from the use of the technology. And OMB was actually mandated under the executive order to issue this policy. So next we can see over here international joint guidances, for example, the one that was released on deploying AI systems securely. So this was a joint release between agencies from the US, UK, Canada, Australia, and New Zealand. So the guidance essentially provides best practices for deploying and operating externally developed AI systems, and they essentially encourage organizations to adapt and adopt this as necessary. And lastly, we have a federal agency joint statement on enforcing civil rights, fair competition, and consumer protection in automated systems. So this was released by 9 federal agencies, including some of the ones that you had mentioned at the start, such as the Consumer Financial Protection Bureau, the Department of Justice, and the FTC, and more, in which agencies have really expressed their commitment to monitoring the use of AI, of course, as well as simultaneously promoting responsible innovation and applying existing laws to the technology. So we can see certain cases where this has already taken place. So for example, the Equal Employment Opportunity Commission recently settled an age discrimination lawsuit with the iTutorGroup based on their automatic rejection of applicants due to age. And a discrimination lawsuit has also been brought against insurance provider State Farm on the basis that the company discriminates against Black policyholders, therefore violating the Fair Housing Act. So we can really see the ramping up of applying existing laws to AI as well.
Great. So something that I feel like is missing from all these laws that have been introduced and a lot of the Biden executive orders and guidances is a comprehensive data privacy act. And it's kind of surprising because when we talk about AI, we usually talk about data because it's so central to ensuring quality AI systems. And so, is there any activity related to data privacy happening at the federal level right now?
Of course. So, in April of this year, we saw a draft released of the American Privacy Rights Act. And while this is not AI specific, it is really important to talk about this because of the implications that it has on AI. Because, of course, as you said, the use of data is so central to the development and deployment of these systems. And specifically, there's a lot more optimistic feeling about this act in particular because of the provision that it would take precedence over privacy in this, and hopefully that it's something in a more timely fashion. It is time to take a deeper dive into activity that's happening at the state level. So, Ella, could you please give us a brief overview of what is activity that's happening in states?
Sorry, I was on mute there for a second. Thanks, Nikita. So, as we mentioned before, states are taking a very active approach on regulating AI, and the targets of the bills range from bias and discrimination to facial recognition technology and deepfakes. And in this year alone, actually, we've seen more than 500 AI-related bills introduced across more than 40 states. So that's not even bills that have actually been passed. And to put that in perspective, analysis from the BSA found that it was at a rate of 50, more than 50 bills per week, actually. And the three states where we've seen the greatest attention on AI are New York, California, and Tennessee. And New York and California aren't that surprising. They have the biggest AI industries, so they're generating the most draft bills. Tennessee is somewhat a little bit more surprising because um, they don't seem like a very tech-heavy state, but when you consider that the state's major industry is country music, it may make more sense. Much of the state's AI policy output is largely driven by the copyright concerns of the music industry. So that's led by what's known as the Elvis Act, which is basically long form called the Ensuring Likeness, Voice, and Image Security Act, which was enacted in January. Um, so we're likely to see even more bills introduced this year and probably more passed as well.
Perfect. So, given that more than 500 bills have been introduced, what proportion of those have been enacted so far?
Right. So a lot of them actually haven't been enacted. You can see here on the map that many are still in the introductory phase. And it's a bit unclear how that's going to change over the next year. And it's also important to note that this map doesn't count state executive orders. There's been a handful of states where governors have issued executive orders, but they kind of have the same impact as a Biden executive order in that they're not always binding, and they tend to target state agencies. But they also tend to target the use of AI in the government as well. So they're looking at opportunities as well.
Of course. And, with multiple states enacting laws, it seems a bit fragmented still compared to federal activity, of course. So, are there any commonalities or themes that can be seen within these enacted laws?
Yes, so actually, out of the legislation passed, we can see a couple themes popping up. A lot of this is deliberate. The states aren't acting independently of each other. They are also coordinating at various forums and things like that. So it's no surprise that we're seeing these themes. But the major ones that we have seen are data privacy, of course, accountability, protection from discrimination, which you've mentioned earlier, transparency, protection from unsafe or ineffective systems. So that's really talking about when AI systems might produce inaccurate or produce hallucinations, for example. And lastly, interdisciplinary collaboration. So trying to involve as many stakeholders as possible in the process of developing AI systems. And another thing to note is the themes here, they're often very interconnected and they don't occur in silos. So, for example, many data privacy bills um, have an accountability component, and many discrimination bills have a transparency component. So there's a lot of interaction between these different themes as well.
Of course. And, that's completely understandable given how all of these issues are really connected with each other. So, with all of this overlap that we're seeing, what approaches are states taking to the issue of specific themes, such as data privacy, for example?
Sure. So there's a spectrum of approaches. Most people know about California, and California actually stands out in their approach. So they're most like the GDPR, which is EU's Data Privacy Act, in that they include a risk threshold that specifically prescribes certain risks to be avoided. However, most states identify a heightened risk of harm to consumers as the applicable threshold. So slightly different, but like the GDPR, they also explicitly require a data protection assessment for processing activities that meet a certain risk threshold. And then two states that kind of stand out are Utah and Iowa, because they do not explicitly include a data protection assessment requirement in their privacy laws. So they take a bit of a lighter touch approach. But overall, 15 states have enacted legislation to protect individuals from abusive data practices. And many others, of course, have proposed bills. But most of these bills include the ability of consumers to opt out of profiling if it furthers a system's automated decision-making processes in a way that produces illegal or other similar effects.
Mhm. And as a theme, of course, relates a lot to other themes as well. So due to these similarities, could you tell me a bit more about the laws that are standing out to you?
Sure. So, sorry, everyone, you'll have to bear with me with a lot of these maps, but at least you'll get to know some US geography. But when it comes to accountability, a large number of states have enacted legislation to ensure that those developing or deploying AI systems are complying with the rules and standards governing AI systems, and they're being held accountable for it. So, um, a lot of them have incorporated these accountability provisions in their data privacy laws. So, for example, in Tennessee, their bill HB 1181, that was passed in 2023, and that includes various data privacy measures related to profiling and requiring those developing or deploying AI to conduct impact assessments. And impact assessments tend to be pretty common mechanisms within data privacy laws, so we'll see that come up again. But these assessments are trying to identify foreseeable negative or disparate effects on certain populations. An important thing to note with this particular bill is that it also gives the Tennessee Attorney General's office the authority to impose civil penalties on those who don't comply with the law. And that's important because we'll see state attorney generals come up again and again when it comes to state AI policy, and I'll go into that a bit later as well. And then lastly, I also just wanted to point to Utah. So Even though they don't have a very strong data privacy component, they were the first state to enact AI-centric consumer protection laws, which are known as the Utah AI Policy Act. And that was recently, that was just in March 2024. And it imposes certain disclosure requirements on entities using generative AI tools with their customers. And so what's interesting about this law is that it limits a entity's ability to blame generative AI for statements or acts that violate consumer protection. And so it was passed in March, as I said, but the companies had quite a quick turnaround time to put in place these compliant disclosures, and they had to do that this month. So it will be definitely interesting to see how the Utah AI Act develops.
Of course. So, another key theme in the use of AI systems is, of course, protecting people from discrimination that can arise due to bias systems. So, how are states addressing this particular issue?
Sure. So protection from discrimination when it comes to AI is a very hot topic, but actually only 3 states have passed legislation to protect individuals from discriminatory practices. So this is California, Colorado, and Illinois. But many other states do have these laws under consideration. But what's interesting is that these laws include algorithmic discrimination. So that refers to when an AI system contributes to the unjustified treatment of people based on certain protected characteristics. So that could include race, ethnicity, sex, religion, etc. And their approach has definitely differed slightly so far. In the cases of states like California, state legislators have sought to protect consumers from algorithmic discrimination by requiring those that develop or deploy AI to assess these systems for potential bias. And California is specifically concerned with the use of AI within criminal justice agencies, particularly when it pertains to pretrial risk assessment tools. So when AI is used to predict someone's chance of skipping bail or skipping a court date, they're very concerned about AI being used in those cases. But in Colorado, legislators have expressly prohibited AI developers and deployers from using biased data generated by AI in various decision making. So it seems like they're a bit stricter, actually. And it's um, the Illinois one is again more kind of a mix of the two as well.
Of course. And so, another key issue that we often think about when it comes to AI is that of black boxes and transparency, which is very pertinent to the discussion. So, could you tell us a bit more about provisions that states are enacting to mitigate this particular issue?
Yeah, so as I said before, transparency and protection from discrimination are often linked. So we can see California and Illinois here again. And they're among 3 states, California, Illinois, and Maryland, who have specific provisions that lay out or that ensure when that individuals know when and how an AI system is being used. And perhaps actually the most famous of these transparency laws is actually not a state, but New York City, Local Law 144, which came out in 2021. But if we just focus on the states for a second, they're required in most of these states, they require employers or businesses to disclose how and when an AI system is being used. So in certain cases, an employer may be required to receive consent from an employee in order to use an AI system that collects data about them. Illinois, which was one of the first laws that was passed on this issue, specifically pertains to video interviews. So if an applicant is interviewing via video and their responses are going to be processed via an AI system, they have to consent to that and they have to know beforehand as well. Um, and then with New York City's local law 144, which is also known as the New York City Bias Audit Compliance, they require annual independent and impartial bias audits of automated employment decision tools. So it imposes transparency and notification requirements. And of course, with New York, it's an interesting case because so many companies are based in the city, so it has a bit of an outsized effect on compliance with certain companies.
Mhm. Of course. So, another key issue is that of the safe, secure, and responsible development of AI systems. So, how are some states tackling those systems that may be unsafe or ineffective?
Sure. So there's about four states that are trying to tackle this and that have passed legislation on this issue. So that's Louisiana, California, Vermont, and Connecticut. And generally, states have approached this issue by directing state agencies to analyze AI systems currently in use and then provide a report to the respective governor regarding potential unintended or emerging effects and risks of these systems. And then within this report, states are then asked to outline policies or codes of ethics that seek to address the identified concern. And I'd like to spotlight Vermont here. It's a useful example. So it's House Bill 410, which was passed in 2022. The state created a division of AI within the State Agency of Digital Services. And that division is responsible for conducting an inventory of all automated systems currently developed or deployed by the state, as well as the potential adverse impacts that may come with it on Vermont residents. So as part of the effort, they're also required to develop a code of ethics as well. So Vermont's is interesting because it may signal the start of new divisions within state governments that we might have to pay attention to.
Oh, that's very interesting. So, of course, another issue that we see in the development of AI systems is that of the need for greater inclusivity. So, how are states particularly addressing this issue?
Sure. So about four states have passed laws on this topic: New York, Illinois, Texas, and Vermont. And they're very much concerned with ensuring that a multi-stakeholder coalition is involved in the design and development and use of AI. And a lot of them are taking a similar approach. So they're establishing task forces, working groups, committees that are all trying to study the potential impacts of AI systems on consumers or particular state residents, as well as identifying potential public sector uses and cybersecurity challenges. So not all of this is doom and gloom. Some are trying to really find opportunities for AI applications within their state governments. And these bodies are also tasked with recommending legislation or regulation to protect consumers. And Texas is interesting. It was passed, this particular law was passed in 2023. And they established an AI advisory council that consists of public and elected officials, academics, and tech experts. And this council is tasked with studying and monitoring AI systems um, that are used or developed within state agencies in particular. And they are also asked to issue policy recommendations regarding data privacy and preventing algorithmic discrimination. So Texas is interesting because they're really trying to involve a huge range of people within not just the development of AI, but also the development of state policy regarding AI. So we're seeing a very socio-technical approach from Texas. And this could be a good state to watch considering how more and more tech companies are now based in the state's capital in Austin.
A comprehensive deep dive into state legislation, the aspects of state level activity that we should be paying attention to.
Yes, definitely. So there were a lot of things I didn't cover that are coming up, but just a few right now. So um, to start off, regulation on autonomous vehicles. You mentioned this in your federal overview. State governments have continued to develop AV laws over the past year. Most of these states implemented or proposed laws actually expanding opportunities for AV use and development. So states are generally pro AV, which is an interesting point. And second, State attorney generals have and will continue to play an essential role in state responses to and regulation of AI technology. So in the past year, state AGs have engaged with AI policies both at a individual level as well as in a lot of collaborative efforts that involve multiple AG offices across different states. So for example, the Massachusetts AG, Andrea Joy Campbell, she issued an advisory that is somewhat similar to what we saw from the different federal agencies that basically just say certain consumer protection laws, anti-discrimination laws will apply to AI. So it was kind of a reminder advisory to companies that they will be subjected to those laws, even if there's no binding AI legislation in that state. And then in June 2023, an interesting kind of interaction between federal and state level AI policy happened when a bipartisan coalition of attorney generals issued a comment letter to the National Telecommunications and Information Administration regarding NTIA's AI policies. And they specifically recommended governance frameworks on high-risk AI and included recommendations like establishing transparency standards for AI decision-making systems, establishing independent testing standards, and requiring regular testing and impact assessments, and also requiring external third-party audits. So that was an interesting interaction between two different levels, and good to see as well that state attorney generals are interacting with NTIA in this way. And lastly, out of the major US cities, we've seen New York City again and again come out as leading the charge when it comes to AI policy. Basically, no other city in the United States is as active on it as New York City. So they have a Office of Technological Innovation. Typically, this has been about digital transformation in the city, but increasingly that this is the office that is handling AI policy for the city. So they have recently announced progress on implementing the city's AI action plan, which is about responsible use of AI, and specifically AI applications that may impact New Yorkers directly. And then two other initiatives have been established, the AI Steering Committee and the AI Advisory Network. And so New York City is certainly a place to watch when it comes to AI policy because they've been quite fast with releasing things, and they've also put out very comprehensive laws as well. So that wraps up our state level AI policies. So I think we can move on to questions now. And we'll just review these. Nikita, would you like to start off?
Of course, of course. So certain questions that were legislation and who they would apply to. In vertical legislation specifically, it's intended for both federal and non-federal use of AI. So it is some of them, for example, with regards to HR tech, specifically say that, and they require both federal and non-federal employers who use automated decision systems to disclose that to their employees. But of course, this really does apply to all companies across the board in terms of specific requirements and what they would entail. So we're really seeing that this is quite broad in terms of application. Unlike, for example, some horizontal legislation, such as the NIST AI RMF Act, which essentially seeks to make the NIST AI RMF law only for federal agencies.
Great. I can take the next question. So I see a question on the New York City Local Law 144. Someone is asking, would the New York City law not be included as one of these enacted laws for protection of discrimination? Yes, so definitely it has a anti-discriminatory component. For the purposes of our presentation, we included it in transparency because of the high emphasis on on auditing input. So it has a very strong transparency component, but it is considered within the anti-discrimination realm as well.
Mhm. So we're also seeing some questions asking if there are any acts specifically for children or any special communities. We'll call the Kids Online Safety Act, which was introduced in May of last year, and essentially mandates online platforms to enhance safety measures for minors, emphasizing transparency and reporting requirements, as well as parental control. So it requires platforms to allow the option of deleting profiles to children, for example, as well as the other things such as time limits, and it demands further clarity on personalized recommendations and ad recommendations, especially for minors. So under this act, there are also civil penalties that will be introduced for each violation. So that's one of the acts in terms of protecting minors to keep an eye out on if any activity takes place in that.
Yeah, and I don't think we've seen anything on pets actually, but when it comes to special communities, I know that the disability community is interested in how AI applications can help, for example, with dyslexia, but I'm not sure how that's come up in certain regulation.
Mhm.
So just looking at a little bit more questions. So I think actually I see a question here on copyright at the federal level. Nikita, I don't know if we mentioned that as much in your portion. I was wondering if you could tell us a little bit more about what's happening there with copyright and AI at the federal level.
Mhm. Of course. So, given the increase, the slew of cases in terms of copyright, I think that's 24 just in the US alone from this and last year. We see several cases such as New York Times versus OpenAI and Getty Images versus Stability AI, both in the US and the UK. So, just it's essentially citing or claiming that these companies have used millions of their copyright images to build their database and build their AI systems. So, one of the acts at the federal level that has been introduced in April of this year actually is called the Generative AI Copyright Disclosure Act. And this essentially aims to establish clear guidelines for the use of copyrighted material in GenAI systems. So, under this proposed legislation, individuals or entities that create or alter training data sets that are used in building GenAI systems must submit a detailed notice to the Register of Copyrights, essentially including comprehensive summaries of copyrighted works and, of course, technical aspects such as respective URLs that they're used filled by the we have over here. I think there's one specifically on NIST and what that would be, essentially what that is.
It looks like Nikita's audio is going in and out, but I can take the next question. So there's one question on whether the US government has mechanisms in place to help companies navigate different state laws. Um, so the US government itself doesn't because of the separation between state and federal powers. So the US government probably won't issue any official guidance on this. But a lot of different law firms, a lot of different policy think tanks and places like that have issued a lot of different advisories to companies in terms of how they can deal with different state laws. And as I said before, a lot of these states are working together to ensure that it's not too fragmentary and that they're not differing too much, and that they're basically each trying to kind of create coalitions with each other. So California and Colorado perhaps are more aligned than Utah and Iowa when it comes to data privacy. So Luckily, companies won't have to deal with kind of 51 different individual laws. There's some similarities across the board.
Mhm. I'm seeing a question here in terms of similarities and differences between the different acts. So that is obviously quite a broad question in terms of what each act mandates, but hopefully, the categories that we essentially described through our presentation in terms of who they're targeting, in terms of the approaches that they're taking, in terms under different verticals, for example, is really quite broad as to what they can be, but essentially there's always some sort of reporting requirements or transparency requirements, as well as a report essentially on what they do. So it remains to be seen what exactly each act will amount to if it passes or comes into effect. Just taking a look at any other questions here, please drop them in the chat as you see them.
So I see one on the NIST generative AI use cases profile. The
Mhm.
question is, what are the generative AI use case profiles recently released by NIST? So if you all are familiar with the NIST AI RMF core, um, the guideline essentially gives some principles and recommendations that companies can follow to have a robust risk management system. And the main functions for that are govern, map, measure, and manage. And each of those functions is accompanied by different actions organizations can take to ensure risk management practices. And the generative AI use case profiles is the Gen AI companion piece to the existing AI RMF core. And so it follows the same format. It's still a draft document, so it will change in a few months once they receive comments. But the document is very similar to the original RMF, and it gives specific recommendations on actions that organizations can take to specifically manage generative AI, not just general automated or AI systems. And we have a resource on this as well that you can take a look at.
Mhm. So we see a question here in terms of efforts that are emerging in law or executive orders to slow the development of foundation models to allow regulatory and social responses to catch up. But as I'm sure we all know, with this technology, it moves way faster than regulation can keep up with, and it's constantly outpacing regulatory and legal mechanisms. So of course, there can be, for example, with the robocall situation where the FCC essentially issued a declaratory ruling banning AI-generated voices in robocalls. We could see some sort of actions coming about like those, which are effective immediately as we wait for the legislative process to catch up. But of course, that can only be seen on a case-by-case basis, and there will have to be continuous updating that is made to different laws, even after out.
And I'm seeing another question here on the New York State bills regarding the prohibition of emotional detection for employment or promotion decisions and whether other states or the federal government might go in the same direction. It's really hard to say. A lot of states have different takes on this particular topic. And especially with the federal government as well, it's difficult to say. I wouldn't be surprised if you see bills introduced in Congress that cover this. Um, right now, as Nikita mentioned in her portion of the talk, that the bills introduced in Congress right now have spanned so many different topics that chances are there probably will be a bill introduced on this. It's really just a matter of whether it will be passed. So I'm sure other states will follow suit in terms of introducing it, but again, it's very hard to say in terms of whether or not they'll be enacted.
Mhm. And maybe we can take our final question, one that we're seeing on the details that are to be provided in reports under different laws. So, of course, this differs from law to law, but in terms of risk management efforts, for example, we're always seeing the need for companies to essentially disclose and develop as well risk protocols to essentially manage the risks that they're facing, and maybe even in some cases tag this to the RMF and to use that as a baseline standard. So I think we're almost done with that's all the time we really have for today. And just before we leave, we would like to draw your attention to our first ever in-person policy event that we're hosting in Brussels on the 3rd of June. Here we will be joined by expert panel members as we discuss AI governance and the EU Act. So the registration link will be up on our website as well. So please do register for that if you're interested, and we really hope to see you there. And thank you so much once again for all of your time today, and we hope that this was informative.
Thanks so much, everyone. And just quickly with the recording question, we will be posting a recap and recording of this in the next few days. So if you go to Holistic AI, our website, we have on our blog resources and webinar recaps that include recaps from our previous policy hours as well. So you'll definitely see this soon. Thanks, everyone, for coming.
Much.